Good morning, everyone, and welcome to today's Coffee Talk, in which we will discuss a topic that I personally find truly very interesting. As you know, Europe, the Protection Board published about 20 days ago, or at least about a month ago, the new guidelines, a draft, let's say draft guidelines on scientific research. I have to say that this is a text we've been waiting for a long time. Perhaps it's been talked about for over about a year now regarding the fact that the European Data Protection Board was supposed to publish a guideline. As we all know, in reality, the topic of research is one where interpretations among the various member states have been very divergent. And this has created several problems. The impact of this, then, we in Italy, we have, in some respects, rather restrictive interpretations as well. We have Article 110 of the Privacy Code. So, specific European guidelines on this subject are objectively very interesting. So, where do we start? Let's start, in fact, with the point that this is number one of 2026. I have to say that when it came out, I actually managed to read through all of them in just one single sitting. They are about 70 pages long in the English version. They are extremely detailed and quite comprehensive in their scope. I do not intend, and obviously we do not even have the opportunity, given the limited time we have in this context, to perform a very in-depth or exhaustive analysis. However, I am very pleased. I thought of bringing this specific topic to our coffee chat today because I truly believe it is worth focusing on. I want to highlight what I consider to be the most crucial and important points. They are under consultation. The consultation period ends on June 25th, so I'm working on behalf of the association, also as the representative of Group 2 at the Ontological Rules and Studies table at the Data Protection Authority. We are obviously working to truly understand what the new developments are and what possible suggestions for improvement could be. So today we will do a comprehensive and very quick overview of the subject. It is truly a very objective and factual piece of writing, but it is also really very, very rich and incredibly full of detail. So, what exactly are the main points we need to cover? First of all, the very first element that we should consider is that the notion of scientific research is introduced, or rather, obviously, in the context of data protection. Or rather, 6 indicative criteria are established, indicative factors that must all be present. And if one of them is missing, I have to justify why I can still consider it scientific research, even in the absence of one of these indicative factors. 6 indicative factors that tell me when I am dealing with scientific research. So this is very important. This, first of all, because the entry, we did not have and do not have within the GDPR a definition. We have a recital, which I believe is number 149 or something like that. Right now, I don't remember exactly the number of the recital that stated that the function of scientific research must be broad, but it was still just a recital and was absolutely generic. Here, on the other hand, we have a whole series of very precise criteria, as you can see. That is a methodical and systematic approach, adherence to ethical standards. So the research project must comply with ethical standards, the verifiability and transparency of the outputs. Pay attention, because this is obviously extremely important. In fact, there are criteria for verifiability. And above all, there must be final transparency regarding the outcome, the autonomy and independence of those conducting the research activity, an objective of advancing knowledge, and a potential scientific contribution. So the fact that the goal we set for ourselves is one that can advance knowledge within the scientific community. So if we want the secretaries that we partly know and who are partly actually present in scientific research, the difference is that, in fact, the definition of these secretaries, among other things, is obviously much more nuanced and much more detailed than what I am presenting here. At this moment, it gives us a much broader scope of application for the regulations. As we will clearly see in the following sections, moreover, in this specific set of guidelines, we actually have, in some way, a very favorable and positive overall approach that we should consider. This guideline from the European Tax Protection Board reflects what had been a legislative choice by the GDPR to promote research, and therefore to introduce, as we will see later, interpretative aspects of the regulation that facilitate and make it easier to conduct research. Naturally, in line with the GDPR, the guidelines reiterate that research activity is not necessarily public, but can also be carried out by private companies and even by businesses for profit. So we don't have a fixed idea. I'm saying this because in Italy, we tend to struggle a bit more to consider scientific research in a broader sense, especially when we move beyond what is obviously considered such. Traditional research with a clinical trial. Culturally, we tend to be somewhat fascinated and only consider scientific research as such, the kind that is carried out in the public sector and not the kind that is conducted in the private sector. On the contrary, in this particular historical period, when we need to conduct research, a lot of research, even on topics like artificial intelligence, which also require expertise, but also significant financial resources to actually achieve results, it is, in my opinion, very, very important that it has been clarified that what matters are the objective criteria, the ones that have been indicated. The subjective element of the person, of the individual actually conducting the research, is not relevant. The first important element is the concept of scientific research. Then another element that we found, which was already present in the GDPR, is actually Article 5, which is the presumption of compatibility in the reuse of data, so in the further processing for research. However, in Italy, due to Article 110, which has been considered a special provision, it has always been interpreted as the sole legal basis. Obviously, as we have done in Italy, it has seen little application. Here, on the other hand, it is explicitly and clearly stated within the regulations that the reuse of personal data, or rather, even more so than the reuse of data, the further processing of such information for the specific purpose of scientific research is considered to be compatible with the original purpose. And this is permitted without the necessity to carry out a formal compatibility test. Another very interesting point, in my opinion, that is clarified, and I have to say, even I have often wondered about this. Many times I have questioned it, and we have had many doubts about it. One thing is the compatibility test to assess whether further processing is compatible or not. Another matter is the need for a legal basis to exist. Here, the guidelines finally clarify, because this point was not clear, not even in recital 50, the guidelines clarify that further processing is always automatically compatible for scientific research, obviously provided it meets the requirements we have discussed. As we saw earlier, however, a specific legal basis is required, which could also be the initial basis, but not automatically. It is still necessary to verify the existence of a legal basis for the further purpose of scientific research. So here, obviously, the issue arises, and in some way, consent, which, as we have said, has always been considered the legal basis for us, is fundamental. Clearly, consent, let's put it this way, it creates some problems because, as a general rule, consent must be specific, of course, especially when you are now carrying out further processing. It is clear that it is difficult to include further processing within the scope of specific consent. Here, however, the guideline opens another door, which is finally that of broad consent. This is also a topic that has been discussed a lot. There is a document from the authorities that, in some way, they were opening the doors. Other documents, also from the European Community, instead considered it inadmissible. Here, finally, things are clarified. So consent is not necessarily only and exclusively for a specific research project or a specific clinical protocol, but it can also be broader consent for areas of research. Therefore, obviously stating in the data processing notice that the data will be used for scientific research in general is not acceptable, but processing data in the field of oncology is considered a broad consent. And so today, in light of the guidelines, it is permitted as far as research is concerned, of course. Then, of course, safeguards are also indicated. So, like the ethical division, but we always go through the ethics committee, and naturally, a very precise definition of the rules for access. And of course, an assessment of what the data subject's reasonable expectations are. So it's true that I don't need a compatibility test. It's true that if I use broad consent in my information notice, I will obviously have to also assess what the data subject's actual expectations might be. As an alternative to broad consent, we can have dynamic consent. There are already many people talking about this type of consent. Dynamic, meaning the possibility in some way to collect the data, for example, for the creation of a data set in order to later provide additional information notices and collect further consents. Perhaps for these could be future follow-up research projects, or even a preliminary and extremely comprehensive form of consent for a specific field of scientific research or for a larger program. And then, at a later stage, for the individual and highly detailed scientific studies that are being conducted that are presented afterwards. This, of course, dynamic consent has been around for quite some time. Clearly, this becomes much simpler. In other words, the digitalization we are experiencing, and therefore the possibility, obviously, of collecting consents that are in some way truly attributable to the data subject. For example, even through systems that are now very widespread, such as OTPs and so on, it is much easier, let's say, compared to what was possible even 5 or 6 years ago to use this tool. Then another extremely important element is the legal basis in addition to consent. We have seen that there is some flexibility when it comes to consent. The guidelines also go into great detail on all the legal bases. In particular, they also discuss public interest and legitimate interest. So why is this relevant, in my opinion? So it is relevant, first of all, because it clarifies once and for all, and this is something we need to understand, that the interpretation of Article 110 of our Privacy Code can only be that consent is the only legal basis. Article 110 reminds us that it establishes what to do when my legal basis is consent and it is not possible to obtain it. These are two completely different things. It's one thing to say that consent is always required. It's another to say that in this specific case, the legal basis is consent because I don't have any others, because I don't have public interest, because I can't use it. Legitimate interests in this specific case where the legal basis would be consent and I am unable to obtain consent, at that point I apply the provisions of Article 110. I believe that this is the interpretation we absolutely must follow, even in a, let's say, at this point, even in terms of compatibility between Article 110 and the GDPR as interpreted today by the guidelines. So the first element, in my opinion, which is very important, especially for us in Italy, is this, namely the fact that the same guidelines list other legal bases that are considered absolutely legitimate. Then, regarding these bases in particular, I focused on public interest, on legitimate interest, on public interest, because it is stated quite clearly. Thank you. In my opinion, this is correct and in line with what we said earlier. Before that, public interest can be used not only and exclusively by public entities. Here, too, we see a disconnect between what constitutes public interest. And here, of course, the elements at the national level that make it possible to qualify an interest as a public interest must be evaluated. Public interest is not strictly linked to the legal nature of the entity exercising this interest. In other words, public interest can also serve as a legal basis, even in cases where the processing is carried out by private entities. If that private entity in that legislative context is pursuing, has as its objective an interest that can be qualified as a public interest. Here, of course, regarding public interest, there would be a lot to say because both at the GDPR level and at the national level. Secondly, if it is another context, privacy, obviously, we have the issue of the legal basis, which can, of course, be a national or EU act or even a general administrative act, but with particular characteristics. So obviously, it is a much broader discussion. However, I wanted to focus on this aspect of public interest, which can also be used as a legal basis by a private entity. When a private entity carries out an activity whose purpose is to achieve a public interest. The other element is legitimate interest, that is Article 6, the possibility of using Article 6. This is not in question when scientific research processes only personal data. Things become more complicated when scientific research processes data under Article 9, for example, health related data. Here it is naturally stated that when processing special categories of data, there must be a combination of Article 6, letter F, with one of the exceptions under Article 9. The second paragraph of the document, in particular, specifically references and highlights as a primary example the provisions found in Article 53 of the regulation on the European health data space. So, however, this opens up the possibility of starting to consider that legitimate interest is indeed a usable legal basis. Of course, I must have a combination, so to speak, with other legislative provisions, and that in some way legitimize me. Excuse the play on words that allow me to use legitimate interest. Then, of course, we all know that legitimate interest, even according to the documents, again from the European Data Protection Board, must obviously still pass the three tests of balancing interests. So I focused on this. Other legal bases are also discussed, but in my opinion, these are particularly the most important ones. And above all, it is very important that the European Data Protection Board talks about this because this removes a restrictive interpretation of consent as the only legal basis in Italy, which in my opinion is not correct, but is nevertheless extremely widespread. Then we have another very interesting part. I'm really giving you summaries because every part of this, of what I've told you, would require a deeper analysis. And as I said, it's 70 pages, so you can understand that I'm really summarizing a lot. The part concerning modernization is very interesting. Here it is reiterated that there is a hierarchy in data processing. In scientific research, there is a hierarchy regarding the format of the data. This, in some way, was also written in our own regulations. That is, where possible, the data must be anonymized, otherwise, it must be pseudonymized or identified. In other words, the logic is that anonymization is the highest level of protection for the individual from whom the data was collected. And so that is where possible. The data must be anonymized. We also know that in the context of scientific research, true anonymization, that is, non traceability, is often complex, not so much because we are interested in tracing back, since in scientific research that's not so important, but it can obviously be relevant for treatment. Naturally, the ability to re-identify is an issue because to achieve real anonymization that truly prevents re-identification is challenging. The level of identification is very low. Very often it is necessary, so to speak, either to delete or otherwise apply anonymization techniques to identifiers, which, if deleted or generalized, can make that set of information too poor from a scientific standpoint. So perhaps the data is analyzed from a scientific perspective, from the GDPR perspective, but it is lacking from a scientific perspective. Regardless, beyond this issue of hierarchy, formats, and data, what is very interesting is that it is clarified that when I go to anonymize, still within the same purpose, still within that research process, I do not need additional legal bases, further ones. So it's clear that if I anonymize, let's take an extreme example, I collect data for research and then anonymize it to use for marketing purposes. Obviously, that's an extreme example. The anonymization in that case would require another legal basis. If, on the other hand, I choose to anonymize the data within that very same process, and for that exact same purpose, then I will certainly not need anything else at all. Legal basis. The last point, this is really just a mention, but I probably intend to do a coffee talk about it. Or perhaps our firm will even organize a seminar on this topic. These are all the provisions, along with all the guidelines that concern the construction of a data set. Here, if you look at the table of contents of the guidelines, there isn't one, not in the index. There isn't a chapter specifically about the construction of a data set in particular. As far as my work is concerned and what interests me, it's the construction of a data set in the healthcare field. However, by searching and reading through all the guidelines, there are actually many indications about what needs to be done in the event that I process data for the construction of a data set. So this is relevant to us because, first of all, very often I have heard on several occasions people claim that it is not possible, that it is not legitimate. In Italy, we do not have specific regulations for this. For example, for databases, for the creation of a database of health data, as was done in France. So the fact that instead, in Italian law, here too, it is very clear that the possibility of constructing a data set, even one rich in health data, exists. It does not necessarily or obligatorily require a legislative provision. It can also be done in light of the principles of the GDPR. It must, of course, be done in a certain way. As I mentioned, there are many guidelines which I will refer you to in another coffee talk or even in a webinar. What is important is that we actually have scattered within the document many indications on what to do when we have this scenario. So I very much so. In summary, right now we are working on commenting on them. We are working to actually highlight and support the things that, as I said, there are many of, and they are very interesting, as well as to provide suggestions for improvement. On some elements that can indeed be adjusted, we are suggesting parts that we obviously believe are lacking. The deadline is June 25th, so in about a month, they will be submitted at the community level. Obviously, all the comments. We can imagine that probably after the summer for sure, because the work will definitely be quite a task. They will be busy and will release the final version. However, it seems to me that the direction has been set. The interpretations that exist are certainly ones that support research and also clarify many points, because sometimes it's not so much about being supportive, but rather about having a clear understanding. In short, applying the rules properly. Very often we are held back by interpretative difficulties or by divergent positions, which then create situations. Thank you. Situations of deadlock that prevent us from moving forward. So these are truly welcome. And we will certainly return to this topic as soon as we have the final version. Have a good day, everyone.